So thanks everybody for joining in this afternoon. Short presentation or a presentation from Ian Heathwood. I actually think I look back and we're returning to the scene of a previous crime, I think back in 2016. I shouldn't say crime, great presentation, because he delivered a topic on this the first time it was introduced way back in 2016. And here we are again on the topic, I think, as well, we'll find out what, but perhaps wind up some more terms with respect to unfair contracts. So Ian Heathwood from Cornwalls Solicitors is on our panel, been on our panel as lawyers for a long time, experts in that subcontracting area, help out our members regularly. Ian's got the good word for us today. He's disembodied. We can't see his face, but he's certainly there. He's going to give us some wise words. So I'll hand it over to you. Thanks, Ian.
Thanks, Jordan. I'm apologising for the fact that I can't do the screen. It was working just before, and all of a sudden it stopped working. So you're blessed in a way. You don't have to look at me. Anyway, thank you everybody for joining. So yes, Jordan's right. These rules have been in for some time, but they're different and they've been changed. And I'm going to explain why it is much more likely now that you are going to be affected by this regime. So we'll just get going. Some of it hasn't changed, and I'll explain all that. But this, I think, is what you need to know. So first of all, as a disclaimer, the usual stuff, it's general information only. It's, we're not providing direct advice on a particular issue. I do give some examples of what I think will happen, which we'll talk about toward the end of the thing. So these federal laws have been around, in fact, since 2010, and it's in the Australian Consumer Law, which is part of the Competition and Consumer Act, which is very exciting. And yes, there's been several goes at broadening it and strengthening it. The first time was in 2016, another one in 2019, and now this time. Now, because of the way it's been structured, it hasn't really bitten in the contracting world. It has been there, but in all the time that it's been around, I think I've seen it, threatened a couple of times, but never proceeded. And the reasons for that is because it was quite difficult to use, because you actually had to go to court or to QCAT, for example, or get an adjudicator to enforce something and say that that term is an unfair term and therefore should be struck out. Now, the problem with that, of course, is, as you know, developers and builders just know that you're not going to go and spend 50 grand going to court to knock out that clause. And so they've been able to get away with things. That's going to change. So come 9th of November, these new provisions come in, with the result that it'll have much more broad application, and it will be far more likely to affect you. In fact, I think it will affect all of you from time to time. So the new provisions, as amended, will apply to new contracts which are entered into on or after 9 November this year, or renewed or varied contracts which are already in place if the renewal or variation was done on the 9th of November. So there are, occasionally you do get variations of contracts that will drag it into the new world, drag that contract. One of the big changes is previously, whilst all you could do was get a ruling that a particular clause was invalid and unenforceable, but now it's actually unlawful to include or rely on an unfair term where these rules apply. So it's a breach of law, and you'll see that there's some fairly significant penalties which back it up. And that's the reason, one of the main reasons why people are going to take it more seriously, and it will apply much more commonly. So it can work to help you as against your clients and the heinous major builders and developers. It can also work against you by your subcontractors might turn it around on you. And we'll talk about that a bit more. So as I said, much more likely now to have real application in the contracting world than it ever has before. So what's changed? So the regime, the unfair contracts regime, has always had three elements, and it still does. The first is that it only applies where there is what's called a standard form contract. But the definition of what constitutes a standard form contract has, I suppose you could say, been relaxed, so that it's much more likely now that a contract you're presented with or that you present to someone else is going to be a standard form contract. So that'll tick the first element. The second thing is it must be for what they call an upfront price payable. This isn't as important as it was before. It just basically means you need to be able to work out the price from looking at the document, or it needs to be just say, the price is $42,510 if it's a fixed contract. It used to be relevant in terms of it. These provisions only applied if the contract was of a certain amount or less than a certain amount, and it depended on timeframes. That's all gone, so that's another reason why it's going to apply more often. The other thing is that the other third element was you had to be someone in the arrangement must be a small business, and that's changed as well. The definition of that's changed, and again, it's another reason why it's going to be more commonly going to apply. Also, the ACCC can prosecute and intervene. They've had that power for a while, but they've been a bit more active in this lately, and there are more powers given to court to do things. And as I said, now not unfair contract terms are not just unenforceable, but they're also illegal, backed up by heavy fines where there were none before. So there was very little consequence for people who were, it's why the builders still have hideous clauses in their contracts. And we'll address some types of those as we go through. So if this regime applies, we go through this procedure. Is the term unfair? There's no actual change to the test of fairness, and I'll address that in a minute. It's still vague as. So if it is an unfair term, then the answer is it's a void, which means it doesn't exist, and it's unenforceable, just like it's not there in the contract. And as I say, plus it's illegal to assert, apply, or rely on such a clause, and courts can issue injunctions to stop someone from trying to rely on them, and they can make appropriate orders to redress, fix up things, and they can make an order regarding loss you've suffered. So if you've had an unfair contract term, and as a result it's caused you loss, and you're in court having a barney, then you can make submissions to say, well, the actual cost to us was $42,000, and the court can order that you be paid that plus interest and compensation. They can also make orders to prevent someone from relying on an unfair clause in the future. So if the clause is void, so if the unfair contract provisions apply, if the clause is in fact unfair, as I say, it's void, it's unenforceable. So you read the contract as if that clause just doesn't exist. And then if it's necessary in order to make the contract make sense to imply another clause, then you imply another clause such that so the contract makes sense. And courts do this all the time. And lawyers argue about what should be implied and what should not all the time. So as I said, the court or the tribunal, QCAT in our case, or indeed it could be an arbitrator or an adjudicator, is the one that decides whether something is fair, and if it is unfair, whether something else is going to be implied in its place. And as I say, adjudicators in cyber payment claim issues. So now, as I say, the difference in the scenario is there's now a real risk that you will be found to have acted illegally, and you could be potentially heavily fined if you've got an unfair contract in your unfair clause in your contract, and you try to enforce it, or the other side does it to you. Now, going back to a standard form contract, what's it really mean? It basically, well, was it a deal that was just put to you, accept or reject, like happens very regularly in your industry? Here's the contract. And there's no discussion about, well, we want to change this, we want to change that. There might only be discussion about pricing, maybe terms of payment, when we're going to be paid and stuff like that. That doesn't count. It's still basically a done deal. You've been given the terms. If you've had a proper opportunity to genuinely negotiate anything in the contract you don't like, then that's reasonable, and it wouldn't be a standard form contract if you'd negotiated 20 changes to the contract. But if you haven't had that chance, that's going to fall into standard form contract. The courts will look at, what's the respective bargaining power. You're, a little contractor with 3 blokes, and you're dealing with Hutchies. Well, there's a big imbalance in power there. And they'll look at any discussions you had before the contract was prepared to see whether the contract's actually based on things you wanted. And they'll also take into account specific characteristics of the person who receives the contract. So that's what I mean by being a small entity, for example. You're going to be in a position where you've got less chance of bargaining, or if there's something wrong with you, which is not going to be the case here because you're all going to be wonderful contractors. It's also about transparency. So if you get this contract that's got 40 pages of closely typed stuff with, like some of the American contracts where they don't even have any full stops, the court will consider that that's much more likely to be a standard form contract because you can't understand it. It's hard to read. And furthermore, it's a presumption that it is a standard form contract. So the starting point is, yes, it is a standard form contract. Now, you who don't want it to be a standard form contract, you go off and prove that it isn't. So, it hasn't changed. And as I said, there's a reversal of the onus of proof. So the person who wants to say it's not a standard form contract has to prove it. So the other change they've made here is that the courts, they've put some specific provisions in which flow from cases where people have successfully argued that for these reasons, it's not a standard form contract. And so they've amended the Act to say, if you are able to negotiate some minor alterations or insubstantial changes, that doesn't stop it from being a standard form contract, because people have argued that before and got away with it. They won't anymore. One of the other ones they were doing is saying, oh, you've got three choices. You can have clause A, B, or C, choose. And they say, well, that's not going to count either. That won't cut the mustard. There was also a line of cases where people said, no, my contract's not a standard form contract because when I negotiated it with John over there and Mary over here, both of them asked for changes and I gave them changes. They're now saying that doesn't matter. It's what happens between you and the two contracting parties. So again, the process is trying to tighten it up, trying to make it apply more commonly. So I talked about before the upfront price payable thing, which usually puts people right off. But what that was all about is these provisions would only apply, or today still do, but after the 9th they won't, if your contract was under 12 months, if you didn't have a contract for more than 300K. So big contracts didn't get the unfair contract stuff in. And if it was longer than 12 months, it was up to $1 million. So instead, it cuts out a lot of contracts in the subcontracting world. But that's gone now. You could be $1 or $100 or $1 million, and you're in if you meet the other two things. So there's no contract threshold value at all. Now, what are the penalties?
Sorry, Ian, can I ask a question which might be
sure.
pertinent for members? Is there anyone who's excluded? For instance, government contracts or council contracts, are they excluded from any of these provisions?
There are some exclusions, but a lot of them relate to the world of finance and stuff, and they won't affect the contracting world. So the government isn't excluded; it's bound. But when we come to look at termination for convenience clauses, I'll explain a few things there that make the position of the government a little bit different to everybody else.
Sure.
But no, it's all in. Everybody's in. Nobody gets out. Now, the previous penalty for a company who was potentially done something wrong was they could get, this is relatively recently, the bigger of 10 million bucks, 3 times the value what they obtained if they got some benefit, or 10% of their turnover, which if you think about it, 10% of turnover sounds pretty hefty. You turn over 5 million, you got to fork out 500 grand. But now it'll be the greater of 50 million, again, 3 times the benefit, or 30% of your annual turnover. And this is why you don't want to have unfair contracts in your contracts, and why the people who are giving you contracts will be trying to avoid giving you unfair terms now. And as always, the lawyers will be trying to work out how they get around everything. But it's going to be a lot more difficult for the big end of town to belt the little guys. Penalties for individual was 500, is now 2.5 million. A lot of money, potentially. The courts won't fine people that much, but they might in extreme circumstances. But the thing to remember with the penalties is it is per breach. So if, for example, you had received a contract that had 5 unfair contract terms, and that was found to be the case, either the ACCC looked at it or you went to a court or tribunal, they could be up for a fine of, so it was a company, up to 30% of annual turnover for each breach. So it's not just once, so they can get whacked. Now, the test of a small business, if you have fewer than 100 employees, so you've got 99 employees, you're a small business. It's currently 20. Most people I know don't think that a company that has 99 employees is a particularly small business, but for the purpose of this now, it is. So again, you can see this broadens out who this is going to apply to. So either you have less than 100 or fewer than 100 employees, or your turnover last financial year was under 10 mil. So you can see now a lot of subbies are going to be in this territory. And if the subbie's in the territory, then the builder gets dragged into that territory as well. And the same with you guys in terms of your subcontractors underneath you. So it's going to apply quite widely. In terms of, if you are subcontracting down to someone doing part of your job or part of the works you've contracted to do, then you're going to need to know whether that's, if you've got sus clauses, you're going to need to know whether your subbies and in fact your suppliers in theory are a small business if you're going to give them a standard form contract. So you sort of think about that as part of your contract engagement process. And I'm happy to have any questions if anyone, I don't know how you run these.
Yeah. Usually we also use our Q&A function if people want to pipe up questions. Sometimes I might just pipe up. If I see Q&A questions, I would generally bring them across to you just for answering.
Yeah, okay.
I have a question out of that in terms of subcontractors and ongoing subcontractors. So these are for subcontracting of a particular type. So I maybe want to do have a solar panel to install a group of them at Mrs. Jones's place, but it's in North Queensland and I'm not there, but I've won the contract in any event. So I'm going to get a subcontractor to do that. That's going to be for a fixed amount. So that would be treated differently than if I just have, Sparky Boy 44 as an ongoing provider of labour to me as a subcontractor. That's treated differently, is it?
Well, it's still a subcontract. If you're say you're Arnold Electrical or something rather, and you're going to engage Horans or something to do something up in Townsville, they're a subcontractor, and in those cases, I know the provisions would apply to those two entities.
Yes, right.
So yeah, but it doesn't apply to your employees.
No,
it does apply to sham contracting.
Yeah, right.
So anyway, okay. Well, I'll if that's okay. Does that answer your question, Jordan?
Yeah. No, thank you.
Okay. Yeah, so you're looking at people underneath you, depending on your terms and conditions, and I'm going to make some suggestions at the end. You sort of have a bit of an idea whether you're going to be caught by this regime. So being more specific, well, how do you tell if a term is an unfair term? There's no list or anything that the ACCC has. They do show some examples on their website, but there are a number of things that can be looked at. That is, would the contract cause a significant imbalance between the parties? So is it heavily in favour of one party? And I think everybody who's listening to this probably knows that every builder's contract does, in fact, result in significant imbalance, always in favour of the builder, and developers are even worse. Is the clause not reasonably necessary to protect that party from some reasonable thing for them to protect? So, and I'll give some examples of things that are not reasonable. So that'll make them an unfair term. Would it cause detriment if applied? This is a difficult one because every clause in a contract generally has a benefit for someone and a consequence for the other party. But basically, if it's, again, one-sided in favour of one party, it's going to be an unfair term. But ultimately, if something rather comes to punch, it's up to a judge. But the lawyers will be arguing about it behind you, on your behalf, not behind your back. But anyway, as I said, plenty to lose because not only is it this term gets struck out now, you've committed an offence and you can potentially be fined. As I said, there's no list, but here's some examples the ACCC say. So automatic rollovers without notice. So JJ Richards is an example, the waste removal people and the rubbish bin people. So they had a clause in one of their contracts which said, it's for a term of 12 months, but it's going to automatically roll over every year. And then it also said all sorts of other nasty things. The price goes up by 10%, blah, blah, blah. That actually went to the High Court and they said, no way, that's unfair, it's gone. Sorry. Provisions which say one party has the right to extend the contract, increase its term, but not the other. And it can do it for unlimited times. Those are examples of cases where the ACCC's found them to be unfair terms. So you do see this in contracts sometimes, not that often. Now, termination for convenience clauses, I bet everybody's been the lucky recipient of one of these. Now, that depends who you are and what the circumstances are. But if you've just got an ordinary old contract with, Hutchies or BMD or, shopping centre owner or something, and they've got a termination for convenience clause in there, and you can't terminate for convenience, that's going to be unfair. That would definitely be struck out these days. However, in the big government jobs, the government's always whilst the governments go on about how we're trying to make it fair for everybody, they don't sort of believe in it themselves. They don't act, despite what the ministers may say, they don't actually act very fairly at times. They say we need a termination for convenience clause in all our contracts because for construction works, because if there's a change of government, the new government might decide they're not going to build that bridge. Or, as an example from yesterday, if the Brisbane City Council decides it's not going to build that bridge at Toowong, as it just did, its contracts, I think, would have had a termination for convenience clause saying, well, if we change our mind, we can pull the pin, because actually they haven't got very far with that. They've just done preliminary works. So that's always been considered to be okay. And then, of course, so they have the contract. So they got the contract. I use Hutchies as an example all the time. It's easy. They would have that clause in their contract with Hutchies. So Hutchies would argue that it's fair enough and reasonable, and it's not an unfair term for them to have that clause in your contract. I don't think that would succeed, but I think it would be reasonable for Hutchies to have in their contract with you a clause that said, if our head contract is terminated for convenience, then we can terminate your contract. So it's not actually a termination for convenience because it's just like, well, we haven't got the job anymore, so we can't do it. But you might still be able to get some compensation for the loss of profit that you would have made or expected to make. So termination for convenience clauses, generally, I think you'll see them fade away most of the time, unless it's a government job. Contracts where one party has a unilateral right to suspend without any reason, that is everywhere. And again, it's highly unlikely to be, it's likely to be an unfair term. And I think you'll see it fade away, except in some particular circumstances where there might be a justification for having it. But it's pretty hard to imagine where that's going to be fair, except these government type jobs. Now, when you've got harsh terms, payment terms, and you will have all seen this, a one-sided right to vary the charge rates or apply or work out what they're going to charge. And you see this particularly in variation clauses, where it says the superintendent, or in fact just the party you're dealing with, will assess the variation and tell you what the price is, and bad luck, that's what it is. And I've seen this too many times, so they just give a ridiculous valuation, a big fight about it. That sort of thing will now be out, one hopes. You do very occasionally see this, where a contract says, look, you've ordered, we've told you you're going to have to put in X in this job. And then you say, well, I've gone and bought it, it's ready to go. And they say, oh, well, under the contract, we don't want it anymore, so we don't have to pay for it. Those sort of clauses where that would almost certainly be unfair. So we've lost someone. Hopefully they haven't gone to sleep. One-sided limitation of liability clauses, and this is relevant because it's everywhere, and in fact we do it. We're going to have to stop doing it. This is where you say in your contract, if I breach my contract and you've suffered loss or damage, it doesn't matter because the maximum you can get against me is X dollars or is X percent of the contract price. So if you've got a set of contracts out there that I've prepared for you, and my practice has prepared for you, and several other practices in Brisbane do it as well, it will have a limitation of liability clause in it, which says, in effect, we start off at 10%, which is obviously unfair, because if you stuff up a job and it costs someone, so you got a $100,000 job and you stuff it up and it causes them $60,000 worth of loss, to say they can only get 10 grand from you is an unfair term, but it was lawful before and it isn't now. So it's going to go. one-sided indemnities, this is everywhere. Basically, almost every contract you'll see from any big builder or even medium-sized builder will have a clause in it saying that you indemnify them for everything under the sun, including things you don't have any control over at all. We've literally just been involved in a case like this where the person they contracted to take insurance to cover risks which were to be potentially incurred by their client and their client's client, which was a mine. And they didn't take out that insurance, and they had an indemnity clause in there. And then someone got injured, and at the end of the day, it was all settled, and people were acting for forked out 100 grand plus about 30 grand in legal fees, I think. Might have been 20, but those sort of clauses they're going to go. They're just going to fade away, hopefully. I mean, I'm being very ambitious, I guess, because I'm normally incredibly cynical from what I say realist, but the changes I think will actually make some difference. Now, one of these, this is what you see increasingly now. People say, "Here's my contract," and inside the contract it says, "Oh, our policy on this is deemed to form part of this contract. Click here to have a look at it." Now, I recently gave a large client of ours, a charitable organisation that operates throughout the country, in fact, the world. They got me to review some contracts, and one of them was from KPMG, the people that don't apparently steal ideas from the government or whatever. Anyway, in it had, and just to let you know, yes, the contract was incredibly unfair, and I can't believe they get that sort of money for doing what they did, basically because they promised to do nothing. But anyway, in that contract, it had a clause that said, our policy so-and-so is deemed to be incorporated in this agreement. Click here, and you click there, and you go there, and then inside that one, it'd say, part of this policy is this policy or this stuff, these terms. Click here, and you go into them, and the same again. So in this particular contract, we end up with 37 links incorporating different terms and conditions, making the 60-page contract or whatever it was into a several hundred-page contract. That sort of stuff, I think, is unreasonable and would be an unfair term. So you watch it. If you're just saying, our privacy policy, click here, that's fine, because that's one way of doing it. But if you had great whacks of, you do see it. It's not quite as bad in construction as it is in some other areas. A force majeure clause. So just in case someone doesn't know what that is, a force majeure clause is a clause which says, if it is impossible for reasons beyond our control for this contract to proceed and for us to discharge our obligations, we can bring the contract to an end. The parties sort of stand where they are. That is, if the builder owes the subcontractor money, they've got to pay the money. But after that, all deals are off, right? So that's what a force majeure clause is. Now, we saw, when I was a young bloke, they were everywhere. Over the years, they disappeared a lot of times. When the pandemic hit, they've come back with a vengeance, and they're everywhere now. In this particular example was a case where ACCC prosecuted Fujifilm, and they basically had a clause which said, if we're delayed from performing, or we just don't perform because of some problem outside our control, then we're not liable to you in any way. But if you are in that situation, you are still liable to us. And the ACCC just said, no, you're not getting away with that one. But you see these things. Unfair warranties. This is a classic, and I bet you've all seen this. A clause that says you're deemed to have read and that you adopt as correct certain documents and drawings that you haven't even seen. And I've even been, or they say, you are deemed to have adopted, and part of this contract is our head contract. And then you say, well, give us a head contract so we can see what it is. Yes, you can redact the financials and stuff. And they say, no, you're not having it. That sort of clause now is just, it is an unfair contract. It always was, unfair clause, it always was. But now, because the regime is more likely to apply to what you guys do, you'll be able to say, no, not putting up with that. Or you can just ignore it, knowing that down the track, if they ever try and put it on you, you'd say, no, get stuffed. It's an unfair term. It's unenforceable. And you prove me otherwise. But you see that one all the time.
Can I ask a question
Yep, sure.
on that out of that list there? Thanks, Ian. We get some questions from members who might have signed up to another organisation who provide sometimes safety advice and sometimes employment advice, and they try to lock you in for 5 years. And at the end of that 5 years, they have a rollover provision.
Yeah.
I believe they do notify you, hey, you'll be rolling over, that sort of thing. Getting out of those sort of clauses, do you think that particular organisation, I'm not sure if I can name them or not, would need to change again the way they approach their terms?
The thinking is that if they give you a reasonable time and an option to then say, no, I'm terminating, that's okay. But if
Sure.
it just is automatic, which is if you think of a certain ratbag organisation which has been before the High Court a few times for giving
Yes.
bullshit advice to people and ripping them off for nothing to pretend that they're doing, helping people with their problems in the workplace. Their terms and conditions are unfair. I've had the argument with them before. It's been to the High Court, not by us, and they've been kicked and belted a few times, but they're still out there,
Yeah.
still sure of themselves, shall we say, in
Yes.
employment, sure things.
Yes.
Yeah, no, that's their contracts are hopeless. I don't know how they get away. They just steal money from people, in
I
my
think they
opinion.
use a lot of bullying and intimidation and fear. I know I've sort of pep talked a few of our members into saying, look, just stick to your guns, give them, under these current terms, not so much these new ones, but just give them that reasonable notice period that will be finishing up, thanks, and send them on their way, and might even sometimes direct them along to your avenues
Yeah,
if they get stuck in a corner.
but you're right, Jordan, and I can remember doing a couple of these with Jason where we just told them, got the client, we write the letters for the client to write to those people, employ Shaw, and just tell them to get stuffed.
Yeah.
And they walked away. But they're traditional. What I see them do is either just give in or don't pay them anything. Don't pay them anything. Don't. They've actually brought a claim. Oh, sorry, that's outside the terms of our policy. Goodbye,
Yeah.
and end up going to lawyers. So they're just a complete farce. That lot, anyway. Now, in contracts, it's very common to say, okay, subby or contractor, you can. So let's say, give an example of a latent defect. You come across a latent defect. In order to make a claim in relation to the latent defect for any extra money or extra time, you must do this, this, and this, and this. Now, if those clauses are reasonable, that is, you tell us what the latent defect is, when did you find it, what's your solution, what do you reckon the price is, and you've got a reasonable time to do that, that's still going to be a fair term. But if it says, if you didn't give us notice within 1 day of finding the latent defect and details of its extent and how to fix it and the price, then you're just time barred and you're still going to go and fix it. And that you do see those clauses, or they're not quite as harsh as 1 day, but that's just not going to fly. It never would have flown, but the regime, the unfair contracts regime, did not apply to most of you, and now it will. You also see lots of limits on being able to sue. Well, depending on what they are, they're probably out. Clauses which say, I've seen clauses, and I'll give an example, where they just say there is no extension of time no matter what. I think that's an unfair term. Clauses which say, yeah, there is an EOT procedure, but you've got to step through 50 hoops, which are nearly impossible to comply with. That is an unfair, always has been an unfair term, but now it's more likely you're going to be able to do something about it. And the same, next point's basically the same sort of thing. Any limitations on people's rights to enforce what would normally be their legal rights are going to be called into question. So that's sort of a list. One of the ones that comes up too is principals saying in their contract that they have a right to direct your subcontractor to do things without your permission or involvement. Those clauses, I think, are unfair, because why should they have that right? If it's an emergency, yes, but not for ordinary things. Liquidated damages clauses where the LDs are really low or inappropriate. They've never been enforceable at law anyway, because liquidated damages clauses are only allowed to the extent that they are reasonable, and that is tested by did the parties consider what the likely loss and damage of the party that suffers the loss because of the delay will incur if there is a delay, and that is determined at the time they enter into the contract. As you guys would all know, it is very, very rare for a builder or client to say to you, oh, well, what do you reckon? You know, I reckon if we're delayed a day, it's going to cost us $4,000. And you go, oh no, no, how do you reckon it's 4,000? And the discussion about it, so on. It's very hardly ever happens. But so this is just the basic gist of what I'm trying to say is these sort of nasty clauses, it is now more likely that you're going to be able to do something about it than you ever were before. So just on that, there's been an improvement over the last several years of contractors in the specialist trade industries saying to people, no, I don't accept this clause. These are my reasons. And there has been an improvement in the number of times people have been successful in doing that. Now, there are still, unfortunately, a lot of subcontractors in particular, and I'll use that term as if like you guys, who just accept whatever they're given and just reckon, oh, I can't do anything about it, I have to take it or leave it. Lyndall's raised your hand.
Sure, Lyndall, do you want to pop a question into the Q&A or the chat function there, and we can put that. Ian will be able to see that, and you can answer that.
Yeah, but just while Linda's doing that, the point is that if you've got a contract, it is worth. I mean, commonly you might identify 30 things that are no good or you want to change, and you know, quite often you'd get maybe 15 of them or 10 of them or a different version of it, which is much more acceptable. Here we go. So I have to click on that, do I?
Yeah, just answer that question.
Okay, so Lyndall's asked, just confirming with LDs, can they be enforced in contracts? E.g., you go over the project by 5 days and liquidated damages are $500 per day. So Lyndall, the test of whether, for the first question is the quantum, the amount of the liquidated damages okay? Is it real? Is it calculated by reference to the actual loss and damage which the client, in this case, could have reasonably expected to suffer if you were late? Now, give a really simple example. If you were, for example, completing a home and it was delayed because of you by a day, and the home was going to be rented out for $700 a week, if the liquidated damages clause said liquidated damages are $700 a day, that would be perfectly enforceable. If, however, it said liquidated damages are $2,500 or a day, it won't be enforceable. And similarly, if it said it's $50 a day, it wouldn't be enforceable either, because it's not a genuine pre-estimate of the loss or damage which the party who's suffering the delay is expected to potentially suffer if and when there's a delay. So yeah, it's test in every different case. Does that answer your question sufficiently, Lyndall?
I think it's a follow-up question. So if the client has a
So
contract.
if the client has a contract, if the client has a contract, ours are $500 per day, and there's a $100 per day. Yeah, see this all the time. So using Hutchies, not trying to pick on Hutchies, is actually one of the better ones, but yeah, if they had a contract with the developer that their LDs for $100 a day, and your contract says it's $500 a day, it's going to be very hard for them to justify how, if that's all they're going to suffer, that you should get whacked for more. Okay, let's move on to this example. There's a couple of examples. How are we going for time? We started a bit late, but anyway, yep. There's a few, just these, I think it's 3 examples I go through. So this is a contract, just get rid of that. So here, this is a theoretical position. You've got 30 staff. Your turnover last financial year was 5 million. So that's fairly common sort of scenario to have. You entered into a contract to do something fixed fee for 215K. As I said before, that used to matter, because if it had been 315K, the unfair terms wouldn't have applied. But now it doesn't matter what the number is. So in this case, 215. You got 4 months for practical completion, defects liability of 3 months, which is lucky. And the contract has one of those exclusions of any opportunity to make an extension of time claim. And you were just given the contract as a standard form and told, take it or leave it. You asked to negotiate it because you said that's unreasonable, and they said, get stuffed. Now, in this scenario, and this is based on something that happened, the dollar signs have many more zeros behind them in this case. It's a major civil works contract in central Queensland for a dam. And the whole site was shut down for months. This is, 3 years ago, when they had all those floods up around Gladstone and stuff. So let's say in this case, as an example, there's a delay due to cyclone damage and lack of access to the site. And despite that, it says you can't get an extension of time. Would that be and you want one, obviously, you probably want not only extension of time, but you want extra compensation for the additional overheads you've incurred in the meantime. So what would be the position? Do the unfair contract provisions apply here? Well, firstly, it is a standard form contract because they just gave it to you, and when you tried to negotiate it, they told you to get nicked. Secondly, you are a small business because you have fewer than 100 staff, and in any event, your turnover is less than 10 million, so you qualify in both arms. Was the term unfair? I think on any reading, anyone normal, apart from a builder, which of course they aren't normal, would confirm, would say, yeah, that's jolly unfair. Why should they be bunged like that, especially for an extension of time? And especially if the person they were contracting to had a right to an extension of time, that would make it even worse. So, okay, so let's say that clause is struck out as void because it's an unfair term. So then do we imply a term which addresses the issue? I think a court would, and it would say, no, you got a right to an extension of time. That's only reasonable. May not give you compensation, but it would give you extension of time. And I think that clause would be illegal, and it could expose them to significant fines. Now, in the case I was talking about up in Central Queensland, the unfair contract terms didn't apply because we were in millions of dollars. And back then, contracts only applied to things of under $1 million, even if they're over a year. So we were outside. Plus, our guys had 200 odd employees anyway. They've got about 300. But anyway, so here's an example of liquidated damages.
Ian,
Yes?
before we jumped onto that, I see there's another question.
Oh, okay.
In the Q&A there around payment
Okay,
terms.
do payment terms apply? E.g., subcontractor payment terms are 14 days, but builder is 30 days from end of month or 60 days. You mean your terms? So your builder is saying to you, just confirm I understand the question. Your builder says in its contract to you that we're going to pay you 30 or 60 days after the end of the month in which you submit your payment claim. And then, I see what you're saying.
The subcontractor has 14, but they're saying, no, we don't pay you then. We pay you at 30 days from every month.
That's illegal for anyone other than electrical contractor. So anyone who's governed by the QBCC Act, you can't do that anyway because it's an illegal payment term. Unfortunately, you're not covered by those provisions. You were supposed to be covered by those provisions, but because when they brought in these amendments, 2004 or something or other, the Electrical Contract Association, as you then were, refused to be governed by the QBCC. So they said, oh, well, stuff you don't get these benefits. So that's currently legal, but that is at least arguably going to be an unfair contract term, because I think a court would take into account, well, hang on, why are electrical contractors, why is that fair to do that to an electrical contractor when it's legal to do it to a plumber or an air and mechanical guy or a fire guy? So I think there's a chance that that would be unenforceable, but I can also suggest to you that builders are going to keep trying to bung it on you, and you should keep trying to, say they can't do it. We actually had a clause once, someone, one of the big builders, I think it was an accident, but it said the subcontractor will be paid in no less than 90 days after payment. In other words, the minimum we will pay you in is 90 days, but it might be longer. And we got that one taken out. But okay, so here's my next example. You got 30 staff, turnover under 100 million. You got a luxury beach home renovation job for one, the Honourable Paul John Keating. When he's in France or Italy each year for his 3 months little holiday, he rents his house on the front base in the water at Sydney Harbour for $4,750 a day, which I believe there is a case of a certain ex-Prime Minister who has a place such as that. You did a contract, you were going to do $250,000 for the renos for him. He gave you the master builder's contract, or it doesn't matter what contract, he gave you a contract, and bits of it you didn't like, so you asked to negotiate, and as people who are old enough to remember who Paul Keating was, he said, pigs will fly first, which is the sort of thing he would have said, but he'd usually have a couple of extra words in there. But you just thought, he's a good bloke, we'll just get on and do the job. 6-month job, you're delayed by 25 days for matters that you had no control over, and you were happy when you saw the contract because it only had $250 a day for LDs. You thought that's probably fair enough. However, what do you think Mr. Keating's going to argue now? He's going to say, no, I think that liquidated damages clause is unfair and I'm void because my loss and damage is actually $4,750 a day because I was going to rent the house out, not $250. So that clause is invalid for a number of reasons, including as an unfair term, and I'm going to sue you for $118,000. Now, what would happen? Do the unfair contract provisions apply here? Standard form contract? Yep, he told you to get stuffed. Here's the contract. That's what you've got. Secondly, you are a small business. Yes, you are, because you've got fewer than 100 employees and your turnover is less than 10 million. Is Keating a consumer? Yes, that's another part of the law. It's not necessarily that relevant here, but it gives him another ground. Are they unfair? Well, he may not be able to get away with it because he was the one that insisted that there's no change to the contract. But he could well, and I mean, that particular gentleman, he probably have a good crack at it, at arguing that it is unfair and that it should be struck out as void. If it is void, he can sue you for the actual loss he got. These bits weren't supposed to be in yellow, but anyway, they are. And he could potentially be subject to fines. You could potentially be subject to fines. So the third one, and I think this is the last one, you'll probably be relieved. You are a small business, 550K state school job, reno job, or extension or something. Standard Hutchie's contract, 10 months for practical completion. Clause that says you indemnify Hutchies against all loss and damage to third parties arising out of any matters beyond control of Hutchies. That is a very common type clause to see. And they even go to the extent of people who have suffered personal injuries, which you didn't even cause. And you see that all the time. And you can't get insurance for that. Just want to explain one thing. It's not quite on topic, but if you sign a contract which says you indemnify the other party for a loss or damage they suffer because of something, that, and it relates to a work injury, that is not going to be covered by your work cover insurance because you're not getting sued for the injury. You're getting sued for the loss of damage that Hutchies in this case suffered because they got sued for it. And their insurer will pursue you certainly. And your other insurance won't apply either because insurance policies don't cover indemnification. There are a couple that do cover some of it, but most of the time, if you've got an indemnity clause in there, you're up for it, unless it's definitely work cover or something like that. So we've had a case on that, and that case we talked about before, the 100 grand settle it was one of those. So in this case, you query that clause and you've got a nasty project manager at Hutchies and he says, no, take it or leave it, mate, but someone else will do the job. Hutchies does suffer a loss caused by some other trade not doing something when they should have. and they have the hide, which really wouldn't be like Hutchies to try and put that on you. But some of you are probably sitting there going, yes, it is like them. Anyway, is it a standard form contract? Yes, they gave you the contract. And when you asked to negotiate, they said no. Are you a small business? Yes. Is the indemnity clause unfair? Well, you'd have to box in your head to think it's fair. So it is void, it's unenforceable, it's also illegal, and Hutchies could be up for a stiff fine if the ACCC took an interest or came before a court. One more example. So this is an interesting and fairly realistic example, I think. You've got a contract, a fairly large one for 1.2 with BMD. It's BMD standard terms, 8 months for PC, so that's probably a bit short, I would have thought. But anyway, defects liability, 12 months, standard stuff. There are some nasty clauses in it. You ask to negotiate, BMD. They also have a nasty project manager and they tell you, no, you're not going to negotiate anything, take it or leave it. In the meantime, part of the job, you subcontract out. Let's say it's a switchboard. And well, it's a very cheap switchboard, I guess. But anyway, you sub out something to a subby for 280K. You, having had these nasty clauses foisted on you, stick them in your subcontract with your subby. Because you think, well, if I'm going to get done over, I'll be able to pass it down the chain. And the subbies and you, well, the subby's a small business. So you've passed on those nasty clauses and again told the subby their terms and conditions. Either they didn't even ask you about it or anything, they just took it and did it, which is what commonly happens. Or you didn't said, no, I'm not getting rid of them because I've got to put up with those clauses from BMD, so you have to take it too. So what happens here? So there's a clause in here, which you would have all seen, which says that you are deemed to have seen the drawing specifications and you accept them, and the site is deemed to have been investigated by you and you fully accept it as it is. And the fact might be that you actually haven't seen some of these technical drawings or specifications or geo reports or something. And you're deemed in this contract to have accepted all this stuff. And that's a really common clause. Further, there's a clause which says you've got no right to claim for loss or damage caused by the defective drawing specifications or any latent defects. Again, you see it all the time. Not all the time, but regularly. So the drawings in this case are in fact incorrect and you've relied on them, so has your subby. So the subby said, well, I had to do 35 grams extra work because of this. I want it from you. You go to BMD and say, well, listen, my subby had to spend 35 grand extra. I'm putting in a payment claim for that as well. So what happens here in terms of unfair contract? We know what happens in practice. BMD tells you to get nicked and you tell your subby to get nicked and we'll have a fight. Or if it's over 45 grand, maybe we don't. But anyway, question, do you have to pay the subby? So there are going to be two questions. Do you have to pay the subby and does BMD have to pay you? So is a subby, remember the three things. Is a subby a small business? Yes. Is it a standard form contract? Yes, because you told him you're not negotiating it. Are the contract terms unfair? Yes, in essence, that's unfair. But your argument would be, it's not unfair in the context because these nasty clauses were forced on me by BMD, and that's my justification for having forced them onto you. So in that situation, it could be that that nasty clause to your subby is okay. But if it's not, and it was found unfair, the clause would be void and you'd have to pay up and you could be illegal and you could be fined. But I think you'd have a pretty good chance there arguing that it's not unfair in the circumstances as against a subby because I was stuck with that clause and I just passed it on. Now, I haven't seen a case like that yet, but I think we'll begin to see them. So now, second issue, does BMD have to pay you? Are you a small business? Yes. Was it a standard form contract? Yes, because they wouldn't let you change it. Is the term unfair? It's definitely unfair, so it's definitely void. BMD must pay because you had no choice. And you and BMD's in a different position because they're the ones that started the problem. So they're not going to get out of it, whereas you might get out of it. Now, so what do you need to do as a business with these new rules coming into play on the 9th. The first thing you need to do is to have a bit of an understanding of how it works, which hopefully this helps you do. If I'm sure that MEA can make available these slides to anyone if they want them. Jordan? Yep.
Yes, definitely. Yep.
Yep. And you're more than happy to have them. And I'm happy to answer any questions, or Michael Cope or one of the other partners here. Just give us a call if you get one of these problems. Remember that you got that 20 minutes free consultation with us. If you've got an issue, use it. Lots of you do. And if we can answer the question in the 20 minutes, it's free for you. If we can't answer it, we hopefully can give you some guidance as to what your options are likely to be and what costs potentially might even be involved. And then if you choose to proceed further, then you can engage us privately to proceed. But that first 20 minutes is free, and you can have as many inquiries as you like. And pleased to say that I've never seen an electrical contractor abuse the system. We did have another tradie once who was a complete imbecile, and he would send us and ring us up for crazy, like this guy, I don't know, he must have been mental, not allowed to say these things anymore, but anyway, he wasn't capable of thinking, let's say. And yeah, we had to talk to the association involved and say, listen, can you just get this bloke to stop asking us all these questions? He's driving us nuts. And they said, you think you've got problems? Anyway, so obviously you need to review, if you've got standard terms for your own, you're unlikely to be providing terms and conditions to your suppliers, because I'm sure all your suppliers will tell you to get nicked. But there will be some that you'll be supplying terms and conditions to, subcontractors underneath you. You need to look at your contracts and think about whether they're fair, or whether they've got some things in you should take out. Now, previously we would have said, yes, we've got some things in there which are unfair, but look, it doesn't really matter. See, if they take you on, they take you on. But leave it there anyway, because they probably won't bother. And that's what the big end of town has always done to you guys. However, now, if you've got an unfair term like a cap on limitation of liability, say you can only get 10% of the contract price from me, no matter how bad I stuff up, that's going to be an offence and potentially going to open you up to not just a void term, but nasty consequences like a fine. So you need to review them and include, where you've got, and not that many of you do it. I'll just step back one step. The terms and conditions which we've prepared, if any of you are using ours, we do have some things in there that need to come out, and we're about to do a big review of all of them. So you need to get in touch with us to go over. And if you've got some other lawyers done it, you need to get in touch with them, or better still, get us to fix their problems. But anyway, if you've got website terms, you need to look at them too, because they're often, a lot of people just steal website terms and conditions from other people, and they often have stuff in it that's just not going to fly anymore. So you should probably be looking at that. But more importantly is your subcontractors things. And when you get a tender or a contract, you need to be now focusing, because I think most of the time you're now going to be in this unfair contract term jurisdiction. You need to be thinking about it, which clauses are unfair and could I potentially get rid of? But you might need to be tactical. There's going to be times when it's in your interest, and this will be normally, that you do a register of contractual concern saying, look, we want clause 2.4 or 10.4 changed because the commercial impact of it is this. You should always give the commercial reason of why you want to change, not just the legal reason. Because if you just give them the legal reason, they tend to get antsy, and they tend to send it off to their lawyers. But if you say, look, that clause is unfair because it means I can't get insurance for that, so I can't bear that cost, then you would normally want to put that in your register of concerns and try and negotiate it away. There will, however, be circumstances where occasionally you might see that there's a contract you've been given that's got unfair terms in it, and you might just decide to shut up and accept it. And then if and when it comes up as an issue, then you say, no, that's an unfair contract term, and if you need your lawyers to help to do that, generally the better position is to try and negotiate them away. But if you can't, or if you know they're a pig-headed bunch, sometimes it can be best just to say nothing and have an argument later. But that's not what I'd normally recommend. So you need to reassess your contract engagement system. That is whether you're tendering and contracting up or whether you're contracting down. And as I say, you need to look at your terms and conditions with your subbies. And you need to be considering when you engage a subbie, they'll almost always be, not always, because you might be using specialists, like, for example, for a big switchboard, you're going to be dealing with people who've got more than 100 employees. And it won't matter what terms, you won't be in this regime. But generally, you just need to have a bit of an idea who you're dealing with and consider whether will this regime apply to them, and if so, do I need to put something different in my contract? So that is something which I suggest you will need a lawyer to help you with. But if you wanted to give it a go first, that's not necessarily a bad idea. But yeah, we're happy to help when we can, obviously. And this is obviously a draft of my speech because the next page actually has on it any questions. So any questions or comments?
Oh, look, I have a comment, which is to say, I remember back in 2016 when you went through this presentation, because it's certainly not my area of ways I can assist members, thinking, oh, okay, that's not really going to impact a lot of our members, is it? So it's all a bit academic. And, here we are, that many years later. I don't see, as you've said many times, our members are going to be caught in this and potentially a problem for them when engaging other people much more regularly, and they'll need to be alive to this issue. And I think this would be a great resource as they're going along, these slides and this sort of commentary, because yeah, it's going to upend a lot of those sorts of contracts that have been enforced on people and those standard form documents. I think it's going to be quite significant this time around.
Yeah, well, let's certainly hope so. And I think you'll see, as has happened, despite it may not feel like it for you guys in the contracting world, but the payment environment has improved over recent years. I know it's still totally unacceptable, but it has got better generally. And I think that's because the bigger end of town's starting to wake up. They're just not going to get away with this stuff. And they've got things like, the trust regime and so on, which occasionally you will fall into, and increasingly so. But of course, the government's pushed all that back again. So the next step comes in after the election because Mr. De Brenny doesn't want master builders campaigning against him again at the coming election. So he's pushed everything back. Well, that's why I reckon he's pushed it back till later. But there's been an improvement, and I think this will work toward improving your world over time. So it's not an instant solution, but I think it's going to help. So anyone wants to give me a call privately later, please feel free to do so, or drop us an email. And I'd like to thank MEA for knowing this is an issue to be dealt with and arranging for us to try and help you guys sort your way through it.
I'd really like to thank Ian again to coming along, bringing this up, helping us with the info, the ins and outs. There's a bit to keep track of, I see. So I think members will definitely want to call on you for your assistance.
Well, we're here anytime. Okay, thank you very much.
Excellent. Thanks, Ian. Thanks all for joining. We'll see you again.